All right. We're going to see how this works. This is my own brainchild invention. Let's see if we can get some interaction here. I thought it would be helpful to go over the survey and to get the responses. And then I know there were a couple of questions and some concerns, and I think this will flow from some of the answers on the survey. Okay, keep eating. Question number 1. I believe there are serious access to justice problems in the United States. 59 strongly agree, 24 agree, 2 disagree, and 2 don't know. I believe increased limited scope services will assist in achieving more access to justice for more low and moderate income individuals. 38 strongly agree, 34 agree, and 12 don't know. On the judges section, remember this is anonymous, which is a good thing, because I want everybody to be honest. I believe that unrepresented litigants would benefit from access to limited scope legal assistance prior to coming to court. 12 strongly agree, 8 agree, and 2 don't know. I believe unrepresented litigants could benefit from limited appearance by a lawyer in the courtroom. 10 strongly agree, 9 agree, and 2 I don't know. I believe that limited appearances by attorneys might assist me in my role as a judge. 8 strongly agree, 8 agree, and 5 I don't know. I believe I can facilitate more individuals obtaining limited scope lawyers to assist in the courtroom setting. 6 strongly agree, 7 agree, 1 strongly agree, and 6 I don't know. Pro bono coordinators, and we have a few in the room. I believe the ability for pro bono attorneys to appear in court cases on a limited basis would increase pro bono services for low and moderate income individuals. 6 strongly agree, 5 agree, and 1 disagrees. Practitioners, and this would also be for bar representatives as well. I believe that providing limited scope services to clients is a viable business model that will allow me to make a living. 7 strongly agree, 12 agree, 2 strongly disagree, 7 disagree, and 5 I don't know. Providing limited scope services to clients puts me at a greater risk of malpractice issues. 4 strongly agree, 3 agree, 2 strongly disagree, 8 disagree, and 8 I don't know. Law faculty. I believe law schools should be providing students an education that includes learning about the ethics of limited scope representation and about limited scope law practice. 3 strongly agree, 1 agrees, and nobody disagrees. That's what judges like, right? I believe that law students could benefit from providing individuals limited scope services in the clinical settings. 2 strongly agree, 2 agree. Legal services providers. I believe that providing full representation services is the only way of providing access to justice to low-income individuals who have cases in court. 2 strongly agree, 1 agrees, 4 strongly disagrees, 15 disagree, and 2 don't know. I believe that supporting the provision of limited scope services to low-income individuals who have cases in court detracts from obtaining civil Gideon in this country. 1 strongly agrees, 3 agrees, 2 strongly disagree, 16 disagree, and 3 I don't know. And you can see the numbers don't actually add up. Some people didn't answer the question, but that's okay. I think that basically what we should be talking about, based on some of these answers, is how do we move forward with doing more limited scope services. And for those individuals who have concerns about it, I want you to talk, speak up, tell me what your concerns are. Richard? Where's Richard? There he is. What was your question?
My question before was, is legal services ever going to incorporate limited scope representation?
Okay. Well, I think we have some legal services representatives in the audience. I don't want to put them on the spot. Ron, um, or Lillian up in Albany. But I think what we should be discussing maybe, rather than whether they will do it, what are the possible things that we could ask legal services to do? And so this is a judge in Kings County, civil court. Yes, Ron? Okay.
That we already do provide some units of representation. As part of one of our foreclosure directors earlier, I don't know if that's still here. Yeah. Who was reminding me that we, for example, will be retained to hearing settlement conferences on behalf of.
Ron, keep your voice up. Albany has to hear you.
So the short answer is yes. There's a variety of ways that we can do it, primarily in the foreclosure context, but certainly we're willing to consider other approaches and other practices.
Hold it.
I don't know what Jim Sandman's answer to that question. They're not funding it at the moment.
Okay, but maybe we can convince him to fund something. How about a pilot project? All right. Would it be helpful, and I'm talking to the judges in the room, and I have housing judges still, yes, and I have some civil court judges. Would it be helpful, for example, Ron, I'm not putting you on the spot, I'm not asking you to answer this, I'm just saying, would a possible project that might be helpful to litigants and to the court is to have legal services, legal aid, legal services providers park themselves in a courthouse and do answers for people that would help issue spot? Would that help you?
If I may, I think that's already going on in the land tenant courts. I think some attorneys are actually working on a per appearance basis. They're actually parking themselves, a lot of regular attorneys, and they'll take either a landlord or a tenant, and they'll represent them just for that day, just for that stipulation, or just for that motion. So I think that's going on already. It's on a paid basis, but
Okay, and maybe not in the best way.
maybe not in the best way, but there is that.
All right.
element.
But do we have, on a critical mass basis, the ability to make sure that almost any unrepresented, and I'm talking mostly tenants right now, but there are landlords that have issues drafting their petitions who need help as well, but do we have enough people who get assistance getting their answers just prepared? Gary?
I think it would be really, really helpful as a judge, it would be really, really helpful if tenants come in and had assistance drafting answers. There's a lot of stuff tenants don't know to put in, and the court feels it's sort of awkward to replace.
Or what about assistance with the affidavit in support of an order to show cause?
Sure, absolutely.
Judge
The
Cohen?
way in which it would be most helpful on the civil side, I can't speak for the housing
That's
side,
fine.
but on the civil side would be to, in some ways, to counter what we've seen as sort of one of the maybe over benefits of the DIY system, which is the people throwing in the kitchen sink, and you don't know which defenses they actually intend, and they come up to you and they often don't know. People say to them, so tell me about why you think X, Y, or Z is true, and they'll say, I don't know what you're talking about. Well, you put it in your answer, you said you hadn't been served, or you said you that you never signed an agreement, or you don't know what that, or is, whatever. And they don't actually, they just put in everything, or they put in whatever someone in front of the DIY has told them they might think about. And in that sense, I might think it might be very helpful to have lawyers down there to sift through, help people, as Gary was saying, help people identify all the defenses they should have, but also help them not put in things that really don't apply to them and understand what they have for an answer.
Okay, well, you may not know, and I'm just kind of jumping all over the places, that we just trained a bunch of volunteers on how to do traverse hearings, because people have difficulties raising service and actually seeing it to the end. Is that something that might be helpful if you had legal services, legal aid, and paid attorneys doing just coming in on a limited basis just to do a hearing on service? Would that help?
Yes.
I heard absolutely from Judge Gennari.
Well, a pro se, self-represented or unrepresented, or whatever,
Okay.
that's going to have no idea what
Okay.
questions asked, to make them produce what records they need to produce as the process server.
All right. In New York, what term do we use? Unrepresented. All right. And definitely not pro se. Okay. Anyway, We made a conscious decision when I took over Access to Justice not to use the term self-represented, and we use unrepresented for the reasons that Judge Fine mentioned. Okay, so I'm just throwing out ideas. Now, some of the judges, I think about 5 or 6 of them, said, I don't know how to facilitate limited scope appearances in my courtroom. You don't have to raise your hand, but there were about 5 or 6 of you that said that. All right, now the CPLR gives you the power to allow people to withdraw from cases, correct? All right. How many, you don't have to actually raise your hand, just in your head answer the question. Can you embrace letting a lawyer go in a case where you want to really hold on to them? I think that's the first threshold question. Can you let the lawyer go who's only going to do a limited appearance? You can answer if you want, Fern. You didn't have to answer. I'm not trying to put anybody on the spot.
Because often the struggle to get an attorney in the first place, having met that need, is very difficult. And the other thing I think, and it might just be, I don't know, I want to say outlier to be fair, but when you're sitting there all day, it seems like everyone is an outlier. So to answer the question, succinctly, I think it would be very difficult. Because often it's a struggle to get them, and you feel like they're going to be back in the abyss that they came from.
Okay, and I know you're doing civil right now, not housing, but I do matrimonials. Why, I don't know, but I do matrimonials. And I know that sometimes I could use a lawyer just to get the issues fleshed out because the litigants don't always know. And I would be happy to get a lawyer in just to, I could figure out what the issues are. I think maybe we have to consider the litigant. Anybody else want to speak on this? The litigant who can only afford the lawyer to come in at the initial, and the divorce would be the preliminary conference, to get the initial ball rolling. That's all they can afford. Okay, so, or they only want the lawyer for child custody. They don't want equitable distribution. And as judges, as much as we don't want to let the lawyer go, what if we had limited appearances? You have to let the person go, correct? All right, so how do we facilitate that, Carol?
Yeah, I mean, to me, even if it's one day, especially if it's in the beginning, it helps set the path.
Okay.
It helps set the litigant on the path they have to go.
All right, so do you want to get that done in your courtroom when you're in the consumer part? I'm just making up a part, but
Well, I know.
you want to have a limited lawyer appearance
We have that in PA1.
with the volunteer lawyer for the day program?
And I'm always very happy when I see it.
Okay, but that's for pro bono, and that's for people who, can get the volunteer. What if we had paid lawyers who were willing to do that? Would you be willing to let them go? Judge Kennedy says yes.
Yeah, that's a choice.
Well, I said strongly agree on everything, because I really think that it's a viable solution to what's going on now.
Okay.
And I would have no problem.
Wayne, you like my judges? Okay.
A lawyer go, it's just that limited purpose. And particularly, I agree with my colleague Carol, particularly at the beginning, because it frames the issue and it gives you a roadmap on how to go forward.
Okay, so how do we get that done in New York? At least you're all New York City people and you've got a few judges from upstate. Come on, how would you get more limited appearance lawyers, we would call them limited scope appearance lawyers, in your part? What would you do?
I think the understanding that they can withdraw easily is a very good thing. And I think on the other side too, someone facing an attorney who's only there for that appearance, I think the CPL provides for a 30-day stay if an attorney is removed that we looking for
That's upon a motion to withdraw, but if there is a retainer that says it's only for a particular event or a particular date, that would clarify that. You wouldn't get the 30 days. So, I'm sorry, Devin, I'll be right back to you. Could you do a court rule and post it?
Could I do a court rule and post it? The 30-day rule?
No, that limited appearances with your rules with respect to.
I'm going to check the law.
Yes, you could do it. Okay, it's okay with me. Okay. All right, it's okay with me. I have to prove the rule, But, well, I don't approve, I just review. Okay, so
Consensus.
do we agree, judges, that,
On Staten Island, something like that would be helpful because I only have 1 and 2 person firms. And I can get a younger lawyer, some guy who's there on a regular basis to stick around for a day and provide services where they may not want to be involved in the whole case.
okay, so would it facilitate helping you if we helped you draft the rule and maybe gave you the forms, the limited appearance forms to be used?
Can't hurt.
Okay, all right.
Certainly,
Okay, Devin?
Further, what I think Phil is getting at is, to respond to your last question, I think I would find it easy to let them go if they were pro bono or if they were legal services lawyers. I think it would be harder for me to do if they were really I'm just being honest, if they were really genuinely private practice lawyers, and I didn't know under what circumstances they'd been retained.
No. What if there was a limited retainer as
No,
well?
I understand that, but I'm not in a calendar of, a couple hundred cases in a day on some of these parts. I'm not going to have time to do everyone's retainer agreement. And so you alluded to volunteer lawyers for the day. That's very easy. They come in, it's the same players. But I think it would be easier to get to Phil's point if you had something that was maybe similar to like an 18B type process, private pay, but similar to 18B. That guy's assigned, or that woman is assigned to the part for the day. They catch whatever comes in for the day. They're not making side deals outside of my courtroom saying, well, pay me this amount. Tell the judge I'm just here for the day and I'll do this for you and that for you.
It's a good idea. I'm getting old, Devin. You think we can get that done in my judicial lifetime? Not my lifetime, judicial lifetime. My grandfather was 103, so I want to be around for a long time. Yeah. Okay, I'm just asking as a stopgap measure.
What did he mean by facilitate? Because at what point does that mean advocate?
No,
or
facilitate means have a court rule that allows a limited appearance with some rules. Okay? Would that help? In the gray sweater. No, it's okay.
But I wondered if the judges would be more comfortable if it was some kind of certification program.
Yes.
Like Massachusetts.
Yes, that's it.
Okay. Would we feel more comfortable with paid, limited scope lawyers if there was some kind of certification program?
Yes.
Okay, raise your hands. Okay, all right. We can do that. Some kind of training.
Standardized as to what the retainers were going to be, what the explanations were going to be.
Okay, that would be helpful, Miriam, and then I'm going to go back to Judge Saunders. And let's not, I want to hear from more than just the judges. Miriam? No, there would be a limited notice of appearance. That would be specific to what is either an event, like settlement only, or date. Okay. If you look at your materials, Massachusetts link is there, and the forms from the Washington, D.C. area are there. All right, now I'm not suggesting you go out and do it on your own, because you know I'm a control freak. But I think we can work on this together to figure this out. Okay, so Michelle, and then I'm going to go to practitioners.
I just want to throw out there because Katie's example I think was good, and I guess I'm a little bit doing a devil's advocate, but if the limited appearance is for the stipulation, then you have a two-attorney stip. I'm 16 years on the bench. There's never a one-time housing court case, so then it's coming back. And it's no longer two attorneys, and you can't vacate that stip, and you have a host of problems.
Okay, no you don't, necessarily if you allocute even when we don't allocute when they're attorneys usually, right?
Unless the attorney asks, I don't typically.
Maybe with a limited appearance, you do.
I do.
Judge Thompson says she allocutes even when there are two attorneys.
The reason why I do that is because I often find that, particularly when there's a person who is in second language, they don't speak English. I don't believe that a lot of times they communicate to the client what they're signing. I've had that in Queens several times. I've had it in Brooklyn several times. So notwithstanding the fact that they're attorneys, and I acknowledge you go to the bench, you have a very competent attorney,
when attorneys flow in the system, but it's my obligation to make certain to understand this and interpret it. I find that that's been a major issue, at least in Brooklyn, particularly with the incoming population from the Middle East, as well as...
Well, any population who doesn't speak a lot of English. But Michelle, let me suggest that limited appearances are going on in many jurisdictions throughout the country, where lawyers come in for one day, or they just come in for settlement, or whatever. So maybe we could look at best practices to make you more comfortable. Would that work? Okay. Anybody else? Oh, Jack, I'm sorry. Hi, Jack.
Hi. Michelle actually stole my thunder a little bit, because I was going to say the same thing she did, because that hypothetical at the beginning.
That was scary.
Yeah, that's what intrigued me, and what I have been thinking, and I don't know what this would look like, but whatever court rule there would be in terms of accepting limited notices of appearance or limited appearances, I think would have to have some flexibility from the court perspective. Would have to give us at least some discretion to say, this matter I'm not comfortable with it just being limited, but that one maybe I am.
Well, the CPLR is still on the books, so technically you do have that.
I'm just saying in terms of formulating court rule or standardizing or something like that.
To identify who you are? In the blue shirt.
Oh, Randy Massey, Legal Services.
Hi, Randy. I recognize you.
We've had pushback from opposing counsel on limited scope representation, and I wonder how to resolve.
Well, interesting, I did get a letter from a landlord firm in an unnamed county who was complaining that some of the judges in Kings County were allowing limited appearances, and how terrible that was, and how it was not a permissible. They were okay with my volunteer lawyer for the day program, but they're not okay with it going bigger than that. And so I referred them to 1.2 of the Code of Professional Responsibility and the judge's discretion to let the lawyer out. Yes?
I wonder if you, I'm sorry, perhaps educating bar associations, the Bronx County Bar Association.
Okay.
And giving a talk or informational seminar.
Well, I have to tell you that this will be available on tape. Not this session, I don't think, but the rest of it's going to be available on tape. Maybe we should do a dog and pony show to the bar associations. I'm the dog. Or maybe I'm the pony. I don't know. Okay. But maybe that's a good suggestion. Educate the bar. In the back. Identify who you are.
Justin Hayes from Legal Services.
Hi, Justin.
We have been doing limited notices of appearance since 2008. We do unbundled services in our provision of
Brief advice.
In the Bronx County courthouse. We do a lot of ghostwriting. But the point I want to make too is that OC needs to do some work in terms of the e-filing system and their own computer systems to be able to record limited.
I agree.
As well. And I really do like this rule about a notice of withdrawal. Because if you want, more limited services or unbundled services, I think there has to be some thought about how to get out of the case easier.
So like what Laura said, I don't know what Laura is, instead of a motion to withdraw, it would be a notice to withdraw. And let me just correct you, there really is no OCA. Okay, OCA is made of people. All right, so, and there are people from our administrative office here who are taking notes as we speak. All right, so that's a good suggestion. Electronic filing is on the way for housing and civil, not in consumer, but no faults at least, and some in housing. I can't give you a date. It may not be in my judicial lifetime, but it's approved and we're working on it. And so we can always work on adding a field maybe within our UCMS system, that's our computer system, that indicates, well, first I'd like to really actually count the number of unrepresented litigants that we really have. That's one thing, but also maybe we can add a field that says limited appearance. That's a good suggestion. Practitioners, what would make you, how many people here are not legal services people who are practitioners or pro bono corners? Okay, all right. You know, so I'm not going to, anybody else besides Wayne? What would encourage you to do more limited scope representation? Nothing? Notice of withdrawal, okay. Okay, maybe I took a leap. Are you interested in maybe doing limited scope? Okay, all right, raise your hand if you're interested. Okay, I think that's a good showing, all right. Okay, so a notice to withdraw would be helpful to you, e-filing with the limited notice noted in the file. Anything else? Lynn? Mm-hmm. Yeah, I don't know if we can do that. I'll check. Barbara, are you putting that down? Okay.
Judge, forgive me, I'm kind of new with this. I'm from out of the New York City area.
That's fine.
But back where I work, CPLR 321 provides that a lawyer gets out of a case by a consent to change attorney or a motion to the court.
Right.
Tell me about this notice to withdraw.
Okay, we don't have it yet. We don't have it yet. Okay. But, okay, if the judge is the person that entertains the motion to withdraw, it's in the judge's hands, correct? To allow a lawyer to withdraw. Just as we do the volunteer lawyer for the day program, the judge agrees in advance that the lawyer is going to withdraw at whatever period of time it is, time period or an event. So it is compliance with the CPLR. It's just that the judge is agreeing in advance without the need for a motion. Excuse me?
That would be the last application this attorney makes for that appearance.
To withdraw.
Judge let me out.
Right. Right, because the lawyer would have to tell the judge in advance. It's not something that you come up with afterwards. It has to be filed in advance. It's not like when you run out, like Laura, I think it was Laura that said it, not when you run out of money and you're not getting paid and then therefore you want to get out. Now we're talking about an arrangement with the client and the lawyer in advance that there's a limited scope appearance or a limited event, you know, through settlement or whatever it is, that is filed with the court at the beginning of the appearance, not when the lawyer is screaming to get out. You understand? Okay. It's still with the judge. But if Judge Straneri, after having studied this very carefully and having consulted with me about his courtroom operations, and we've studied the best practices in the state, country, excuse me, and he puts up a court rule saying, I will honor limited appearances on these kind of cases, and this is the procedure, he can comply with the CPLR. Because that's what we do with the volunteer lawyer for the day. All right, you'll hear about that this afternoon. What else, Gina?
Under 321, the client signed a consent to change attorney.
Yes, it's a similar thing, exactly. So the client, and I understand what Devin's concern is about whether the client has informed consent, but we have problems with full retainers and informed consent. So it's not limited just to a limited appearance. Huh?
Should we be allocating the client as that they understand that this is a one-day deal or a...
Listen, I am safety girl. I think it's always a good idea to make sure the client understands. If I was the judge, and that's what I told the DC judge, I would make sure that the client understands that they have signed a limited retainer, that the judge, the lawyer's only going to do, you know, the child custody part of the divorce. Okay? All right. I have 5 minutes. Okay. Okay. He's going to give me an extra minute. Any other practitioner concerns? Yes?
Practitioner, I think training and unfamiliar practice areas
Okay.
would encourage more.
Okay, more training in substantive areas as well? Okay. Okay, legal services providers. Justin?
I was excited here in Massachusetts that one of their first projects for unbundled services was in the probate area.
Mm-hmm.
It's a huge unmet need that isn't really...
We have somebody here from Surrogates Court. They're listening.
It's not a service that really legal services, legal aid provides to the city, and it's a desperate need. And
And it affects moderate income people very severely.
Yes.
Yes.
In a low-income community like the Bronx.
And low income.
That's a transfer of wealth
Okay.
from one generation to the other.
Good suggestion.
It's unmet.
Maybe we can try a pilot in one of the surrogates courts. How about that? Okay, Lynn, and then Randy. And then I'm going to read the results from Albany.
Lynn, you can keep it in Albany, can't hear you.
The City Guard Justice Center has been running a pilot planning the state's law project, which is an unbundled project, and they will not make appearances in service court, but they give advice, and it's all expert team lawyers. So you can refer to that. I mean, I'm sure it will rapidly get filled out again, but I think it's replicable. It's a very good project.
The surrogates courts can be very difficult for someone to navigate through, so we could use more attorneys doing surrogate work, and it can be very expensive. Randy, you're the last point or question.
Okay, the last question is what would encourage legal services for I as a practitioner. We held a clinic to do pro se Article 78s. I did them, and I sent them to Supreme Court with the stamp that said prepared by assistance of counsel. Once in a while, I'd be called by the judge to ask for.
You're in the Bronx, right, Randy?
I am. But
Okay, Peter, you're off the hook.
once in a while, the Supreme Court judge would call legal services to find out who drafted it and why I wasn't in front of it.
Okay, that's a culture that would have to stop judges. Unless you saw something that was really unethical in the papers, that's what not limited appearance isn't about. If you don't get a chance to call the ghostwriter and say, come in here and explain why you wrote this. Okay, we can't take any more questions from
It's connected. I find that sometimes the triage piece is critical because people don't know how to advocate once it's limited often or at certain times, and I think practitioners are very useful.
Okay.
And so that
I understand, and that's still the reluctance to not to have the judge, the lawyer there, and I get it. I would prefer to have a lawyer in a matrimonial all the time, but there are a lot of unrepresented litigants in matrimonials. So that's a whole nother conference, okay? The role of the judge and being an engaged judge, okay? So we'll talk about that. Another conference, just judges, and I have some hints on that, but let's not talk about that today. Okay, let's read the Albany results, just so that you know what our brethren upstate are thinking. I believe there's serious access to justice problems in the United States. 10 strongly agree, 3 agree. 1 disagrees, and 1 doesn't know. I believe increased limited scope services will assist in achieving more access to justice for more low and moderate income individuals. 6 strongly agree, 3 agree, 6 do not know. I believe, judge question, I believe that unrepresented litigants would benefit from access to limited scope legal assistance prior to coming to court. Strongly agreed, 3. I believe unrepresented litigants could benefit from limited appearances by a lawyer in the courtroom. 2 strongly agreed. And no other responses. I believe that limited appearances by attorneys might assist me in my role as a judge. 2 strongly agreed, no other responses. I believe I can facilitate more individuals obtaining limited scope lawyers to assist in the courtroom setting. 2 strongly agreed, no disagreement. Okay, pro bono attorneys about limited scope, encouraging more pro bono service. 1 strongly agree, 1 I don't know. Practitioners, I believe that providing limited scope services to clients is a viable business model that will allow me to make a living. 3 strongly agree, 1 agree, 5 I don't know. Providing limited scope services to clients puts me at greater risk of malpractice. 1 agree, 1 strongly agrees, 6 I don't know. Law faculty, there is no law faculty in Albany attending. Legal services providers, I believe that providing full representation services is the only way of providing access to justice to low-income individuals who have cases in court. 1 strongly agrees, 2 disagree. I believe that supporting the provision of limited scope services to low-income individuals who have cases in court detracts from obtaining civil guardian in this country. 2 disagree and 1 I do not know. Okay. So, guess what? We're going to ask you to do this survey at the end of the day. All right? So I hope that some of the I don't knows will switch to either agree or disagree. And feel free to agree or disagree, but let's not have I don't know. If you don't get any information from the sessions, ask questions And of course, you know, you can always call my office and try to, you know, ask us what the information they